All right, let's dive right into this fascinating explainer. We're looking at a super relatable couple taking on exorbitant immigration fees, which, believe it or not, turned into an absolute masterclass on constitutional law. I mean, it's a classic David versus Goliath story, right? A citizen and her husband just trying to navigate a massive bureaucratic maze, standing up to a massive government department. And honestly, that's why this matters to us. At some point, we all face the friction of government red tape. But what makes this specific case, Minister of Home Affairs versus Dominique Liebenberg, so incredibly captivating isn't just the human element. It's how a seemingly simple administrative dispute accidentally exposed this huge procedural blind spot in the legal system. It really forces us to ask, when a court strikes down a law, what exactly are they striking down? And who ultimately has the final say? So let's get into it.
Here is our roadmap for today. First, a battle over visa fees. Second, the rushed High Court order. Third, the Constitutional Court steps in. Fourth, acts versus regulations. And finally, the verdict, where we'll see why legal precision absolutely matters.
Section 1. A battle over visa fees. So our story begins with the South African citizen Dominique Liebenberg and her Senegalese husband. Because, behind every massive constitutional ruling is usually just a regular person trying to solve a problem. Dominique was simply trying to keep her family together. To ground this timeline for you, he entered South Africa in December 1997 on a Senegalese passport. By April 1998, he was granted a temporary permit and political asylum. Fast forward to June 2000, and the couple gets lawfully married in Johannesburg. But right here is where the friction really starts. Shortly after their marriage, the husband lost his Senegalese passport, and that single event set off a massive bureaucratic hurdle that would push this couple straight to the brink.
Well, when Dominique applied for a temporary residence permit for him, basically just trying to bridge the gap while they applied for a proper immigration permit, the Department of Home Affairs flat out refused it. Their logic? They insisted he had absolutely no legal status to remain in the country without a physical passport. They basically told Dominique, look, you have to replace his passport first. And in the meantime, she had to pay this incredibly steep set of fees just to keep him legally in the country and able to work.
To put that financial wall into perspective, a basic spouse visa was 310 Rand, but to even just seek a job, that required a non-refundable, non-guaranteed fee of 560 Rand. And if he actually found a job and wanted to take it, another non-refundable, non-guaranteed fee of 1,100 Rand. I mean, imagine being asked to pay money you might never, ever get back, just for the chance to work, all while you're scrambling to replace a lost document. It's crazy. This steep financial barrier pushed Dominique to launch urgent proceedings in the High Court to challenge these specific scheduled regulations.
Section 2. The rushed High Court order.
Okay, so Dominique actually goes to the High Court totally unrepresented. No fancy legal team, just her drafted papers, and a strong sense of injustice. And in a wild twist, the Department of Home Affairs didn't even fight her. Instead, they just agreed on a draft order. This order effectively invalidated those exorbitant fees for alien spouses and dependent children and essentially declared the regulations constitutionally inconsistent. The High Court saw that the two parties were in agreement, and they basically just rubber-stamped it. Boom! Victory for Dominique, right? Well, not quite, because when a court makes an order, it becomes binding law, and this particular order had some serious flaws.
If you read the verbatim text from this court order, it is actually pretty shocking. You can see blatant spelling errors immortalized right there in a binding legal document. Sude instead of study. Permanently instead of permanently. It reads like a hasty first draft, definitely not a refined judicial decree. And remember, Dominique drafted this without a lawyer. The fact that it was adopted as an official court order word for word is highly unusual.
So how does something like that happen? In the subsequent review, Justice Squiella noted that the motion division of the High Court was under immense pressure. Courts are incredibly busy. Their dockets are jam-packed. When two parties agree on a draft, a judge under severe time constraints might just sign off on it to clear the roll. But the result here was an obscure and poorly drafted order that now technically bound organs of state. It was basically a messy piece of legal machinery thrown right into the middle of the constitutional gears.
Section 3. The Constitutional Court steps in.
Now, when a lower court strikes down a law for being unconstitutional, it doesn't just quietly go away. The system has built-in checks and balances. So, the Ministry of Home Affairs applied to the Constitutional Court to confirm the invalidation of these rules, which is playing completely by the book. But when the application landed on the justices' desks, they didn't just nod and agree.
They immediately noticed a glaring jurisdictional problem. The Constitutional Court asked a fundamental question. Do we even have the power to confirm this specific type of order?
And the crucial point here is a major legal mismatch. Section 172(2) of the South African Constitution explicitly states that the Constitutional Court is only required to confirm the invalidation of overarching primary laws. We're talking about an act of Parliament, a provincial act, or any conduct of the President. But what did this High Court order actually do? It merely invalidated subordinate regulations regarding visa fees and vaguely referenced some unspecific conduct or requirement. The Constitutional Court realized, hey, we are being asked to confirm something that is completely outside our specific constitutional mandate.
Section 4. Acts versus regulations.
To truly understand why the Constitutional Court halted the process, we have to distinguish between an act and a regulation. I know, it might sound like boring legal semantics, but it is actually the bedrock of how a democracy functions and separates its powers. An act of Parliament is the absolute primary law. It's debated, drafted, and passed by the national legislative authority, the elected representatives of the people. Because it carries the weight of the entire democratic legislature, striking it down is a massive deal. That is exactly why the Constitution insists that if a lower court strikes down an act, the highest court in the land absolutely must review and confirm it, just to ensure the legislature isn't being improperly undermined.
A regulation, on the flip side, is entirely different. It's a set of subordinate rules made by a minister. Parliament passes the overarching act, right? But they delegate the day-to-day details, like exactly how much a specific visa fee should be, to a minister to figure out. A minister exercises subordinate delegated authority. Therefore, a regulation is not an act of Parliament. If a High Court finds a regulation invalid, it's invalid right then and there. Its invalidity does not need the grand formal confirmation of the Constitutional Court.
Now, the minister's legal team tried a pretty clever workaround. They argued that because the overarching Aliens Control Act has a definition section, Section 1, that says this act includes the regulations made under it, the regulations are essentially elevated to the exact same status as the act itself. Therefore, they argued, the Constitutional Court should confirm it. Nice try, but the court firmly rejected this. They stated clearly that a simple definition clause cannot magically convert a subordinate ministerial rule into a primary act debated by Parliament. The hierarchy absolutely remains intact.
Section 5. The verdict. Precision matters.
So you've got this rushed order, typos everywhere, and a complete misunderstanding of acts versus regulations. Furthermore, the justices looked closely at paragraph 3 of that messy High Court order. It didn't even read like a proper invalidation. It acted more like a mandamus, which is just a fancy legal term for a command to an organ of state to fix an issue. It commanded Parliament and the respondent to correct the constitutional inconsistency. It didn't explicitly say Section X of Law Y is hereby declared invalid. It left the Constitutional Court having to guess and speculate on what precisely was being struck down. And let me tell you, highest courts do not deal in speculation.
So, after analyzing the rushed typos, the misclassification of subordinate regulations, and the vague constitutional declarations that read more like a command than an actual striking down of law, what did the highest court decide? Did they confirm Dominic's victory over the fees?
The answer? A flat no. The Constitutional Court completely dismissed the minister's application to confirm the High Court order. Now, just to be super clear here, this didn't mean Dominic had to suddenly go back and pay the fees. The High Court's order invalidating those regulations still stood on its own because, as we learned, regulations don't need Constitutional Court confirmation to be struck down. But the Constitutional Court absolutely refused to lend its highest seal of confirmation to an order that didn't meet the strict jurisdictional criteria of Section 172.
The ultimate takeaway from this explainer, perfectly captured by Justice Scalia, is that legal precision matters immensely. To quote him directly, where orders invalidate legislation, such orders be specific. Court orders that strike down laws are incredibly powerful tools. They literally bind the state. They rewrite the rules of society. Therefore, they must be crystal clear to maintain the absolute integrity of our legal system. We just cannot have courts rubber-stamping vague, typo-ridden agreements between parties when the actual constitutionality of laws is at stake.
So, I want to leave you with a final thought to reflect on. Sometimes, legal technicalities feel super frustrating, like it's just bureaucracy getting in the way of common sense justice. But considering the immense power courts have to literally erase laws, why is it actually a good thing that they are strict sticklers for the rules? It is entirely about the balance of power. I really encourage you to dive deeper into how these strict legal hierarchies actually protect all of us from both bureaucratic overreach and judicial chaos. Thanks so much for joining me on this explainer, and keep questioning the systems around you.